Imagine spending decades working hard, building savings, paying off your home, and looking forward to a peaceful retirement. Like many Americans, you may believe that once you stop working, your biggest financial challenges are finally behind you. However, for millions of retirees, one major concern remains: the rising cost of long-term care. A serious illness, unexpected disability, or chronic medical condition can create enormous financial pressure and potentially threaten everything a family has spent a lifetime building. Many people assume that Medicare will cover all healthcare expenses during retirement. Unfortunately, according to official Medicare guidelines, that is not always the case. While Medicare covers many medical services, it generally does not pay for long-term custodial nursing home care. When someone requires ongoing assistance with everyday activities such as bathing, dressing, eating, or mobility, Medicaid often becomes the primary source of financial assistance. This is where many families encounter a difficult reality. In order to qualify for Medicaid long-term care benefits, applicants are often required to reduce their countable assets substantially. In many states, individuals must spend down much of their savings before becoming eligible for assistance. For retirees who spent decades saving responsibly, this requirement can be both surprising and frightening. However, there is important news that every family should understand. Federal and state laws provide several completely legal planning strategies that may help protect certain assets while still allowing individuals to qualify for Medicaid benefits. These strategies are widely used by attorneys and financial planning professionals throughout the United States. Understanding how these tools work may help families make informed decisions long before a healthcare crisis occurs. Before discussing specific planning options, it is essential to understand why Medicaid rules appear so complicated. Medicaid is jointly funded by the federal government and individual states. Although federal law establishes broad requirements, each state administers its own Medicaid program and may adopt different financial standards within federal guidelines. As a result, eligibility requirements vary significantly across the country. While many states continue to maintain strict asset limitations, some states operate under different thresholds. For example, New York currently permits significantly higher asset retention levels than many other states. California has also implemented changes affecting asset eligibility requirements. Because these rules change periodically and differ from state to state, individuals should always verify current regulations in their specific state before making financial decisions. Another critical Medicaid rule involves what is commonly known as the 5-year look-back period. When an individual applies for long-term care Medicaid, the program reviews financial transactions completed during the previous 60 months. This review includes bank records, property transfers, gifts, and other financial activity. If Medicaid determines that assets were transferred for less than fair market value during the look-back period, a penalty may be imposed. This penalty can delay eligibility for benefits, requiring applicants to pay privately for care during the penalty period. Consequently, transferring money or property to children immediately before applying for Medicaid may create serious complications rather than solving financial concerns. Understanding the difference between countable and non-countable assets is equally important. Countable assets typically include checking accounts, savings accounts, stocks, mutual funds, certificates of deposit, and additional real estate holdings. Non-countable assets often include personal belongings, household furnishings, one automobile, and, in many circumstances, a primary residence occupied by the applicant or spouse. Effective Medicaid planning frequently involves legally repositioning assets in ways recognized under federal and state law. One of the most commonly used tools is an irrevocable funeral trust. An irrevocable funeral trust is designed specifically to set aside funds for funeral and burial expenses in advance. Although discussions about end-of-life planning are often uncomfortable, preparing for these expenses can reduce emotional and financial stress for loved ones during a difficult time. Funeral costs in the United States can be substantial, and many families find themselves facing unexpected expenses during periods of grief. With an irrevocable funeral trust, an individual places funds into a legally established trust that is dedicated solely to funeral and burial costs. The most important feature of this arrangement is that it is irrevocable, meaning the individual cannot later withdraw the funds for personal use. Because the money is no longer considered available to the applicant, many states exclude these funds when determining Medicaid eligibility. State regulations concerning irrevocable funeral trusts vary considerably. Some states impose specific contribution limits, while others permit larger amounts if the expenses are considered reasonable. In many jurisdictions, contributions of approximately $15,000 per person are common, although exact limits depend on state law. Individuals should always verify current regulations within their home state before establishing such a trust. One major advantage of an irrevocable funeral trust is that it is frequently exempt from Medicaid's 5-year look-back period. This means that, in many cases, individuals who are only slightly above Medicaid asset limits may be able to establish this type of trust and immediately reduce countable assets without triggering a transfer penalty. As a result, this strategy is often considered when immediate Medicaid eligibility is necessary. Another important area of Medicaid planning involves married couples. Frequently, one spouse may require nursing home care while the other spouse remains healthy and continues living independently at home. Medicaid refers to the healthy spouse as the community spouse. Without special protections, the cost of long-term care could potentially leave the community spouse with insufficient resources for daily living expenses. Recognizing this concern, federal law includes provisions intended to prevent spousal impoverishment. One of these protections is known as the Community Spouse Resource Allowance. In 2026, many states permit the community spouse to retain approximately $162,000 in countable assets, although exact amounts differ depending upon state regulations. These protections help ensure that the spouse remaining at home can continue paying household expenses and maintaining financial stability. However, some families possess savings that exceed the allowable limits. In these situations, attorneys sometimes recommend a Medicaid-compliant annuity as part of a broader planning strategy. Medicaid distinguishes between assets and income. Large cash reserves held in savings accounts are generally considered countable assets. Monthly income, however, may be treated differently, particularly when received by the community spouse. A Medicaid-compliant annuity converts excess countable assets into an income stream payable to the healthy spouse. For example, instead of maintaining excess funds in a savings account that could affect Medicaid eligibility, those funds may be exchanged for guaranteed monthly payments through a properly structured annuity. This conversion can potentially help the spouse requiring nursing home care qualify for Medicaid, while simultaneously providing ongoing income to the community spouse. It is extremely important to understand that not every annuity qualifies under Medicaid regulations. A standard commercial annuity purchased without proper legal guidance may actually disqualify an applicant from receiving benefits. Federal law requires Medicaid-compliant annuities to satisfy strict legal standards. Generally, these annuities must be irrevocable, non-assignable, and actuarially sound. Additionally, many states require that the state's Medicaid program be named as a beneficiary for remaining funds under certain circumstances. Because these requirements are highly technical and vary among states, individuals should always consult a qualified elder law attorney before purchasing any annuity for Medicaid planning purposes. For families seeking long-term protection of significant assets, one of the most powerful legal tools available is the Medicaid Asset Protection Trust, commonly known as a MAPT. Unlike strategies intended to address an immediate financial crisis, This type of trust is designed for individuals who are planning years in advance. A Medicaid Asset Protection Trust allows individuals to transfer certain assets, such as a primary residence, investment accounts, or additional savings, into an irrevocable trust structure. Once these assets are transferred, the individual generally gives up direct ownership and control over them. Although this may sound concerning, the arrangement provides important advantages under Medicaid rules. For example, individuals who transfer their primary residence into a properly established trust are often still permitted to live in the home for the remainder of their lives. In many situations, they may also continue receiving income generated by trust investments. However, they typically lose direct access to the principal assets placed inside the trust. Because the assets are no longer fully available to the individual, Medicaid may eventually exclude them from eligibility calculations. In addition, properly structured trusts may protect assets from Medicaid estate recovery, helping preserve wealth for future generations. However, timing is absolutely critical. Transfers into a Medicaid Asset Protection Trust are subject to Medicaid's 5-year look-back period. This means that a full 60 months must generally pass between the transfer of assets into the trust and the individual's application for Medicaid benefits. If someone establishes the trust and then requires nursing home care before the 5-year period expires, Medicaid may impose a penalty period and delay eligibility. Consequently, this strategy is most effective when implemented well before any serious health issues arise. This highlights one of the most important principles in long-term care planning. Planning early creates options, while waiting until a crisis occurs may significantly limit available strategies. Despite its advantages, a Medicaid Asset Protection Trust is not appropriate for everyone. Because the trust is irrevocable, individuals surrender a substantial degree of flexibility and control. For instance, if a homeowner later decides to sell a property that has been transferred into the trust, the transaction generally requires involvement and approval from the trustee. Likewise, access to principal funds may be limited or prohibited altogether, depending on the specific terms of the trust agreement. As a result, individuals must carefully evaluate whether the long-term benefits of asset protection outweigh the loss of direct control over their property. To better understand how these planning tools may work together, consider a hypothetical example. Imagine a married couple, Bob and Mary, who have spent decades building financial security. They own their home outright and have accumulated $150,000 in savings. Suddenly, Bob experiences a severe stroke and requires full-time nursing home care. When Mary applies for Medicaid on Bob's behalf, she learns that their countable assets exceed the allowable limit established by their state. Without proper planning, a substantial portion of their savings could be spent on long-term care expenses before Medicaid assistance becomes available. Working with a qualified elder law attorney, Mary explores available options. She establishes an irrevocable funeral trust to prepay future funeral expenses, thereby reducing countable assets. She also considers a Medicaid-compliant annuity to convert excess savings into an income stream that will support her while she continues living independently at home. Unfortunately, because Bob's medical crisis occurred unexpectedly, they never established a Medicaid Asset Protection Trust while they were healthy. As a result, their home may remain vulnerable to future Medicaid estate recovery efforts. Their experience demonstrates an important lesson shared by many elder law professionals. While some strategies can help during a crisis, the strongest asset protection opportunities usually require advanced planning. Ultimately, Medicaid planning is highly complex. Federal regulations, state laws, and administrative rules frequently change, and mistakes can result in significant financial consequences. A single incorrect transfer or improperly structured financial arrangement may delay eligibility or trigger penalties. For this reason, individuals and families should always seek advice from a qualified elder law attorney licensed in their specific state before making major financial or legal decisions related to Medicaid planning. Taking action early, understanding available options, and obtaining professional guidance can help families protect assets, preserve financial stability, and prepare more confidently for the future. As families approach retirement, one reality becomes increasingly clear. Long-term care planning cannot be ignored. Healthcare costs continue to rise, and unexpected medical events can place enormous financial pressure on even the most prepared households. While no one can predict the future, taking the time to understand Medicaid rules and available planning strategies may provide valuable protection for both assets and loved ones. Whether someone is considering an irrevocable funeral trust, a Medicaid-Compliant Annuity, or a Medicaid Asset Protection Trust, the most important factor is timing. Many of the strongest planning opportunities are only available when action is taken well before a medical crisis occurs. Waiting until long-term care becomes immediately necessary may significantly reduce the number of available options. It is equally important to remember that Medicaid regulations vary from state to state. Asset limits, exemption rules, eligibility requirements, and estate recovery provisions differ across the country and may change over time. Because of these differences, families should avoid making major financial decisions without first consulting a qualified elder law attorney who understands the laws in their specific state. Professional guidance can help families avoid costly mistakes, preserve financial resources, and develop a strategy that reflects their personal goals and circumstances. Every family situation is unique, and no single planning solution works for everyone. Careful preparation, informed decision-making, and early action remain the foundation of successful long-term care planning. Retirement represents the culmination of decades of hard work, sacrifice, and financial discipline. Protecting those achievements requires planning, education, and a willingness to prepare for challenges before they arise. By understanding the available legal strategies and seeking appropriate professional advice, families can approach the future with greater confidence, knowing they have taken meaningful steps to protect both their financial security and their legacy for future generations.